A 2022 state voting rights law designed to address complaints of vote dilution of minority groups is already having real-world effects, with the town of Newburgh embracing a ranked choice voting system for their council elections in response to a lawsuit alleging Black and Hispanic voters were unable to elect candidates of their choice under the status quo. For more on how the New York State Voting Rights Act is informing local elections in the Empire State, we're joined on the Capitol Press Room by David Imamura, the former top Democratic representative on the state's bipartisan redistricting commission and was the lead plaintiff attorney in the Newburgh case. Welcome back to the show, David.
David, great to be back. Good to see you.
Good to see you as well. Well, before we get into the 2022 voting rights law and how it's being implemented, can you walk us through some of the election practices it was designed to address?
So the New York State Voting Rights Act was designed in part because right now across the country, the Federal Voting Rights Act is being rolled back. So, back in the Shelby County decision, the United States Supreme Court eliminated preclearance. This year, right now, the United States Supreme Court is considering a challenge to Section 2 of the Federal Voting Rights Act. So the New York State Voting Rights Act was designed to deal with the fact that the Federal Voting Rights Act is very much in question. And so there are a variety of things the New York State Voting Rights Act does. It creates a preclearance regime similar to the one that used to exist before Shelby County. And it also creates a vote dilution claim similar to what exists under Section 2. And that is what is at issue right now in the towns of Newburgh and Mount Pleasant, is the fact that these municipalities have an election system that systematically disenfranchises people of color in their communities.
The idea of vote dilution, though, it can be a hard one to grasp because it almost sounds like a sour grapes argument. Like you're in a community where I didn't get the person that I wanted, and I think we should go back and change the rules. Why is it not that? How is it different from, say, a minority of voters not getting their way?
So, there's a couple of reasons, right, David? First off, this exists in the federal voting context, right? I am the first Asian American county legislator in Westchester County. And I can tell you that politics is representation. And what was occurring in these municipalities was that you had entire blocks of voters that had no representation whatsoever. So in the town of Newburgh is 40% Black and Hispanic. But because you have at-large voting, you have a system where 51% of the voters were choosing all of the elected representatives, and 40% of the community, despite being 40% of the community, was getting 0% of the power. And so that's why in this system, they're not asking for control of the town. They're asking for a seat at the table, a seat that they literally didn't have ever until the last year.
And as part of this settlement from this multi-year lawsuit, the town of Newburgh is expected to replace its prior at-large electoral system with what's known as proportional ranked choice voting for town board seats. I know what ranked choice voting is. What is proportional ranked choice voting?
So proportional ranked choice voting is similar to ranked choice voting, except that it's for multiple seats. So in New York City, for instance, right now, right, for New York City Council, you eliminate candidates one by one until a single candidate has a majority. Proportional ranked choice voting is similar, except it takes another step, right? So once a single candidate reaches the winning threshold, then those votes are redistributed proportionally. And if a second candidate fails to get the winning percentage, then you eliminate additional candidates until you get two candidates at the winning percentage. So what this effectively does is they're for 4 seats. It effectively freezes the town to the 2. So communities of color are able to mathematically win at likely 2 seats out of 4. So it ensures they have representation, but it also addresses a concern that the town had, which is the town did not want to have districts. They wanted the entire town to be able to vote in town-wide elections for everything. And so this was a compromise where in lieu of districts, we created a system where the entire town votes, but racial minorities were able to get a seat at the table.
And is the system in and of itself a victory? Does the system represent compliance and an execution of the State Voting Rights Act, or are the outcomes still an important part of this that will really determine whether the spirit and letter of the state law is being followed?
It's both. There's a very good question, David, but it's both because on one hand, the electoral system itself is better than the at-large system in ensuring that there's minority representation. But the proof is in the pudding, right? If the system doesn't allow racial minorities to have candidates of their choice, then it doesn't work, right? But we are confident mathematically that racial minorities are going to be able to get their seat at the table. What has happened with other communities that have adopted this way. So, for example, Australia uses this for their parliamentary elections, right? It ensures that minorities are able to get representation that they otherwise wouldn't get.
What happens though if in the town there are no black or Hispanic candidates that decide to run? Is that a problem in and of itself?
Well, no, because as long as a candidate supported by the black and Hispanic populations is elected, then that's okay, right? We're not talking about just facial representation. We're talking about actual representation, and that means people supported by the black and Hispanic communities.
And how do you gauge that? Are you going to be running exit polling to find out how people voted? Because this is supposed to be a secretive process, though theoretically, we don't know who's voting for who.
So this is a very complicated question, David, that you're hitting on, and this is what drives most federal Voting Rights Act litigation. Is we have a secret ballot in this country. How do you figure out who's voting for who? And so, facially, right, you can look at precincts that are heavily black or heavily Hispanic and figure out who did the people in those communities support. And then, there's multiple layers of analysis that you can do beyond that, and to determine, who black and Hispanic communities supported. And so based off that data, we were able to determine that the candidates supported by the black and Hispanic community were losing over and over and over again. And so, going into this new system, we'll be able to do exactly the same analysis, look at precincts that are majority or largely black and Hispanic, and determine, okay, who are these folks supporting, and are the people they're supporting actually winning at the ballot box?
Well, are there other examples of how this law is being utilized in communities around the state by racial and ethnic minorities to try to increase their representation locally? And if there are cases, where do they seem to be heading?
So, my firm, as well as the election law clinic at Harvard Law School, who was our co-counsel in the Newberg case,
Harvard Law School. Look at me. Aren't we great?
I am but a lowly Columbia person, so whenever I talk to these Harvard folks, I feel like I need to hide because of how smart and intelligent they are. So we joined with our co-counsel, and in the other case we brought was in the town of Mount Pleasant. So this was the first case that was brought under the law. And it alleged that the Hispanic population in the town of Mount Pleasant, around 20% of the population, was systematically being disenfranchised in a similar way to what was happening in Newberg. Despite making up 20% of the population, they had never been able to elect a candidate ever to the town council that they supported. And so you had a similar situation where a community of color, despite making up a large fraction of the town, was getting 0% of the power. So we brought a lawsuit in the town of Mount Pleasant. It appears we're going to actually settle that case. The settlement is supposed to be voted on by the town council tonight. So today is March 10th. You in the future will know whether or not the town of Mount Pleasant actually approved it or not. But the town it appears that the town is going to approve it. And so they have come up with a different system where instead of, we are going to create districts in the town of Mount Pleasant. And the idea will be to create a district for the Hispanic community, which is largely concentrated in the village of Sleepy Hollow. And so starting next year, the Hispanic population will have a district they can call their own, and which will almost certainly elect a candidate of their choice. And this is important in the town of Mount Pleasant because here you have a town that literally made it illegal for anyone to house a migrant, and you could actually go to jail if you house the migrant, right? So this is something that the Hispanic population definitely deserves to have a voice in.
Are there implications for races outside of local or state legislative races for applying this law? For example, is there any way that a county executive race could be impacted by this law, or should we think of it only in that sort of legislative races?
Well, so there's different components in the New York State Voting Rights Act, David. There's the parts on vote dilution, which is what we've been talking about, but then there are parts just generally about voting. So the New York State Voting Rights Act requires, language access, requires having, a certain number of precincts. So that will impact county executive elections. But, the vote dilution parts of this, I mean, this is potentially affecting almost every municipality in the state. And it's not just town and city elections, it's school board elections, it's fire districts. And another component of this that we haven't talked about is that in both of these cases, the municipality spent literally millions of dollars fighting this, and then under the law have to pay the attorney's fees of the plaintiff's attorneys. So in the town of Mount Pleasant, they spent $2.2 million for their own attorneys, and then had to pay plaintiff's attorneys $1.6 million for something they could have done for free 3 years ago when we initially sent them a demand letter. Similarly, in the town of Mount Pleasant, the town has paid about $1.4 million to their attorneys, and they're paying us around the same, right? So the town of Mount Pleasant is spending almost $3 million for something they could have, again, done for free 3 years ago had they decided not to litigate, right? So I think this is an important message to municipalities all across the state that if they face something like this, they have two options. They can either litigate and spend millions of dollars of taxpayer money, or they can give racial minorities a voice that they haven't had in their local governments.
And are you proactively looking around for cases to bring? Are you looking at demographics of different communities and saying, hey, here's a large minority. I wonder what their experience has been at the polls?
Well, I can say that we've been in discussions with various community groups across the state.
Do they reach out to you, or do you reach out to them?
It's mostly they reached out to us.
They probably heard you on the Capitol Press Room.
Okay, right. But what is also happening, right, and the reason why we brought Mount Pleasant and Newburgh was because they clearly were in violation of the law. So the town of Mount Pleasant, they hired someone who is, a well-known person on the Capitol Press Room, Jeff Weiss, who did an analysis of the electoral system in Mount Pleasant and said, you are in violation of the law. You can either litigate, or you can change your electoral system to give the Hispanic population a seat at the table. So that is what's at issue here, right, for municipalities going forward is, look, at the end of the day, the law is basically numbers, right? The law says, is there what's, quote, racially polarized voting? Are there racial minorities that meet certain thresholds, right, that are being systematically disenfranchised by the election system, right? Be it either at large elections or be it by districts that are not actually reflective of the population, right? And then not actually allowing racial minorities to select candidates of their choice. And so municipalities, if and when they get this demand letter, have a choice as to whether to litigate or not. And so, I would hope that, the town of Mount Pleasant initially was doing the right thing. They hired Jeff Weiss. They were doing an analysis. They were determining whether they're in violation of the law, and then they decided to litigate it. And then, and that's how 3 years later, we're ending up in exactly the same point where we could have been before, where, we could have just, converted to a district system and called it a day.
Well, lastly, is this something that you think is going to impact school board elections around New York as well, or does it not necessarily apply to their elections?
I think it absolutely could apply to school board elections. I think, if anything, school districts are actually more prone to the problems inherent in voting based off race than even, Democrat versus Republican elections.
Is that because they have more at-large districts than, say, most municipalities with their local elections?
That's part of it, right? I also think it's just kind of the how the dynamics of school board elections, right? Voter turnout is substantially lower. Oftentimes, racial minorities are less likely to vote in school board elections, right? And so that results in these kind of lopsided election results. So I think, if anything, school board elections are more prone to the problems that the vote dilution statute was meant to address.
Well, we've been speaking with David Imamura. He is the former top Democratic representative on the state's bipartisan redistricting commission and was one of the lead plaintiff attorneys in the Newburgh town case that was citing the New York State Voting Rights Act. David, as always, thank you so much for making the time.
Good to see you, David.
And for more Capitol Press Room content, visit capitolpressroom.org or wherever you download your favorite podcasts.